In this video, I'll explain how Florida contractors are losing tens of thousands of dollars because one change order mistake, and it's completely legal. And by the end of this video, you will learn the single documentation error that gives property owners the right to refuse payment for extra work. You'll learn the exact Florida statute behind it, and you'll learn how to protect yourself so this never happens to you. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I've spent years helping contractors, developers, and business owners navigate construction disputes across the entire state. So when I tell you this mistake is destroying contractors financially, I'm not guessing. I'm watching it happen. Let me set the scene for you. A general contractor takes on a renovation project in South Florida. Midway through the job, the property owner walks the site and says, "Hey, while you're at it, can you move that wall? Can you upgrade those fixtures? Can you add recessed lighting in the living room?" The contractor says, "Sure, I'll do it." He does the work, he does it well, and he sends the invoice, and the owner says, "No." Not no, the work was bad, not no, you overcharged me, just no, I'm not paying for that. Now you're probably thinking, that's ridiculous. The owner asked for the work, the contractor did the work. How is that legal? But here's the thing. In Florida, it is legal, and the reason why comes down to what I call the verbal trap. The verbal trap is the most expensive mistake a Florida contractor can make. It works like this. The owner requests additional work, the contractor agrees verbally, the contractor performs the work, the contractor bills for the work, and the owner disputes the charge because there's no signed written change order. This is not a gray area. Florida courts have ruled on this repeatedly. When a construction contract requires written change orders, verbal agreements for additional work are unenforceable. It doesn't matter that the owner asked for it. It doesn't matter that the owner watched you do it. It doesn't matter that the owner's wife picked out the tile herself. Without a signed change order, that contractor has no legal claim to payment. Now here's where it gets worse. Most standard construction contracts in Florida already contain a written change order clause. The AIA contracts have it. The consensus docs forms have it. Customs contracts drafted by the attorneys have it. This clause is already sitting in the agreement the contractor signed, and most contractors never think about it until they're owed $40,000 and a judge is telling them that they can't collect. But that's only half the problem, because the verbal trap has a second layer that catches even contractors off guard who think they're being careful. I call this second layer the silent waiver. Here's how it works. A contractor does a written change order on the first round of extra work. Great, the owner pays for it. No issues. Then the owner asks for more changes. This time, the contractor skips the paperwork. The owner pays anyway. No problem. Third time, same thing, no written change order, owner pays again. Now in the fourth request, the contractor does the work without a written change order, and then the owner refuses to pay. You're thinking, wait, the owner paid the last two times without a written change order. Doesn't that set a precedent? Actually, no, not automatically. Florida courts look at this through the lens of contract modification and waiver. The fact that the owner paid informally before does not permanently waive the written change order requirement going forward. The owner can reassert that clause at any time. So the contractor who got comfortable, the one who thought we have a good relationship, we don't need all this paperwork, that contractor just donated his labor and his materials to someone else's property. The reason why this is so devastating is simple. Construction disputes in Florida are expensive to litigate. Filing a construction lien under Florida Statute 713 has strict deadlines and procedural requirements. Going to court takes months, attorney's fees add up, and the whole time, the contractor is out the cost of labor, materials, and lost opportunity on other jobs. Now I know some of you are thinking, I've been doing this for 20 years and I've never had this problem. And I hear you. But here's what actually happens in the real world. The contractors who get hit by the verbal trap are not careless people. They're busy people. They're on the job site at 6 in the morning. They're managing crews, handling inspections, dealing with permit delays. When the owner walks up and says, "Can you add this?" stopping everything to draft a formal change order feels like overkill. It feels like slowing down the project for no reason. But that instinct, the instinct to keep moving, to keep the client happy, to deal with the paperwork later, that instinct is a trap. The verbal agreement feels like a handshake deal. It feels binding. It feels real. Instead, it's vapor. It disappears the second the relationship sours. And relationships in construction sour all the time. Budget overruns, timeline delays, a spouse who changes their mind about the kitchen layout. The moment tension enters the picture, that friendly verbal agreement becomes a weapon pointed directly at the contractor. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. So how do you protect yourself? The answer is what I call the paper shield. It's not complicated, but it has to be consistent. Step 1. Read your contract before you sign it. Look for the change order clause. Understand what it requires. Most contracts require a written document signed by both parties before any additional work begins. Know your obligations going in. Step 2. Never begin extra work without a signed change order. I don't care how small the change is. I don't care if the owner says, "Don't worry about it, I'll pay you." Get it in writing, get it signed, then start the work. Step 3, use a simple change order form. You don't need a 20-page document. You need the scope of the additional work, you need the cost, you need the impact on the timeline, and you need both signatures. That's it. 1 page, 5 minutes. Step 4, document everything in writing, even beyond the change order. Send a confirmation email. Send a text message that says, "Per our conversation today, you've approved the following additional work at the following cost." You want to create a paper trail. Florida courts love paper trails. Judges love paper trails. Step 5, and this is the one most contractors skip. Do not accept verbal approval as a substitute for written approval, even under time pressure. The owner says, "Just start the work and we'll sign the paperwork tomorrow." Well, that's the verbal trap resetting itself. The paperwork comes first. The work comes second, every single time. Now, you might be wondering whether there's any scenario where a verbal change order holds up in Florida. And the answer is, well, it depends, but not in the way you think. There are limited circumstances where a contractor can recover for work performed without a written change order. Courts have occasionally allowed recovery under theories like quantum merit or unjust enrichment. These are legal doctrines that say it would be unfair for the owner to keep the benefit of your work without paying for it. But here's the reality. These claims are harder to prove. They're more expensive to litigate, and the outcome is uncertain. You might recover your cost, you might not. You almost certainly won't recover your full profit margin, and you'll spend months, sometimes years, fighting about it. Compare that to having a signed change order. With the signed change order, the dispute is over before it starts. The document speaks for itself. There's nothing to argue about. So yes, there are exceptions, but relying on an exception instead of following the rule is like driving without insurance because you're a good driver. The one time it matters, you'll wish you'd done it differently. And here's what contractors need to understand about Florida construction law in 2026 and beyond. The legal landscape is not getting friendlier. Courts are enforcing written contract provisions more strictly, not less. Property owners are getting more sophisticated. Their attorneys are advising them to use a written change order clause as leverage, as a way to control costs after the fact. This isn't about trust. This isn't about whether your client is a good person. This is about protecting your business, your employees, and your livelihood from a legal technicality that can wipe out your profit on an entire project. The verbal trap catches contractors every single week in this state. The paper shield takes 5 minutes to implement. The choice is obvious. Now, if this video saved you from making a costly change order mistake, hit that like button and subscribe to my channel. I break down Florida business law, construction disputes, and contract issues so you can protect yourself before there's a problem, not after. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.